Hello guys, welcome back with me. Don't forget to like, comment, share, and subscribe. Seamen's right to maintain and cure. Maintains and cure are benefits that an injured seaman receives from an employer during the course of recovery. Maintains includes such expenses as the seaman's rent or mortgage, utilities, properly taxes, and then wait guys, wait. Seaman injured is someone who is a captain or crew member aboard a vessel in navigation. Also, similar to workers' compensation, maintains and cure does not require that the seaman prove any fault or further injury. The employer is required to pay. The Dawes Act is federal law that gives seamen a statutory right to sue their employer for personal injury damage. However, a seaman must spend at least 30% of their time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seaman a statutory right to sue their employer, it also eases the burden of proof needed to prove cautions between the employer's negligence and the seaman's injury. Under the Jones Act, the employer's negligence only needs to play a part in the seaman's injury rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in state court under the Jones Act are not removable to federal court. When the death of an individual is caused by a wrongful act or neglect occurring on the high seas, the Death on High Seas Act guarantees that a personal representative of the descendant can bring a claim. Federal law establishes exclusive jurisdiction for admiralty and maritime cases in the federal district courts absent any language indicating the country within a statutory granted right, such as the Jones Act. However, the saving the suitors clause reserve any non-admiralty remedies that may be available to an individual. An example of an admiralty remedy is a suit in which the claim is brought against the ship. Federal law created certain statutory rights for employees who are not necessarily seamen, but nonetheless work on harbors or vessels that are under repair or being built. This law covers longshore workers, ship repairers, shipbuilders or shipbreakers, and harbor construction workers. Moreover, the injuries must occur on navigable waters or an adjoining area such as a dock. This law provides for the payment of compensation and medical care for an individual injured while on the job or survivor benefits. The Outer Continental Shelf Lands Act extends the Longshore and Harbor Workers Compensation Act. The employees engaged in offshore drilling on outer continental shelf. In the U.S., jurisdiction over admiralty law matters was originally given to the federal courts. However, today most admiralty cases can be heard by both state and federal courts under the saving the suitors clause in the Title 28 of the United States Code, the expectation to this any matter involving maritime property. Those cases may only be tried in federal court. If a state court presides over an admiralty case, the court is required to apply admiralty or maritime law rather than its state law. Without maritime law, injured seamen would be left on their own to counteract the suffering they sustained while working. Anytime a ship employee becomes injured or sick, the vessel owner is required to reimburse their losses. Maritime law refers to this reimbursement as maintenance and cure, meaning that until the seaman fully recovers, that employers must provide for their affliction. The court views this obligation as an unquestionable duty that the ship owner owes any seaman aboard their vessel. Seamen are also eligible to recover full wage for the length of the voyage during which they sustained injuries or illness. An employment contract may dictate the amount of unearned wage a seaman can receive. Maintenance and cure refer to the benefits a seaman is entitled to until he or she recovers and is fit for duty. However, there is a maximum medical improvement limit that can control the amount of compensation received. Because many ship owners are allowed to pay the highest amount possible, they either follow old rates or regulate cure benefits by handpicking covered medical treatments. The U.S. Supreme Court states the duty to provide maintenance and cure must be broad and inclusive. In the case of compensation, the seaman is almost always favored when skepticism is involved. In some instances, an offshore accident can cause injuries that are so serious that they change a person's life permanently. These types of injuries are so notorious that the medical and legal community has a word for them: catastrophic injuries. When a person has this type of offshore injury, their injuries will likely impact the rest of their life. In some instances, certain injuries mean that a person won't be able to earn a living with physical work as they once did. In other cases, it means that every aspect of a person's life is impacted by the severity of their injuries. Often, these offshore injuries require a lifetime of medical care. When workers are suffering from an accident they didn't cause, they deserve compensation for the care that will make their life as comfortable as possible. Maritime burns injury, one of the most catastrophic injuries that can occur in a maritime accident, is a burn injury. If you suffered a burn injury during a maritime accident, it is vital to contact a top-rated Houston Maritime Burn Injury lawyer as quickly as possible. Arnold has helped hundreds of injured seamen advocate for their rights, including those who have suffered serious burn injuries while working offshore. That's all from me. Thank you for watching. Don't forget to like, comment, share, and subscribe.